Welcome to the Star Chamber. I'm Ryan Swayze, a retired Air Force Lieutenant Colonel and the founder and president of the Walk the Talk Foundation, a nonprofit that advocates for and advises currently serving and former military service members going through the arduous journey of administrative processes and investigations in our government.
And I am Francescagraham, a retired Army Lieutenant Colonel and the Chief Operating Officer and Chief Advisor for the Walk the Talk Foundation. For all our returning guests, welcome back. And for our new listeners, thank you for tuning in. Before we begin this week's topic, please do not forget to hit that subscribe button, check out our Walk the Talk Foundation website, and hit that donate button if you think we're doing a good job. Also, check out our newsletter, the DoD Times Redacted, on all the socials, including LinkedIn, X, Instagram, and Facebook. Links in the description. All right, Star Chamber listeners, let's get started. All right, everyone, welcome back to another fantastic episode of the Star Chamber. Today, we are very lucky and very excited to have as a guest our very first lawyer on the show, who is going to teach us all about everything the team needs to know about JAGs, what JAGs do, what JAGs don't do, lawyer, legal stuff writ large, etc. So his name is Mr. Jason Wareham. He is a trial and appellate lawyer who has tried dozens of state, federal, and military courts and administrative hearing cases. Many of his cases were litigated under the highest stakes, including some of this country's most highly classified capital cases. Jason joined the Allen Vellon Wolf Helfrich and Factor P.C. Is that right, Jason? Did I get it all in there? Okay.
Wow.
Yeah.
Allen Vellon Wolf Helfrich and Factor. Yeah.
Okay, great.
All right. Impressive.
Following a successful career as a United States Marine Corps judge advocate, where he held the distinction of being one of the longest continuously serving trial and appellate litigators, litigating some of the highest profile and most complex criminal and national security cases available. Jason has been recognized as a, quote, genius level attorney and litigator, unquote,
Awesome.
this genius level, by one of the most experienced practitioners in that field for more than 35 years, even a presiding trial judge himself. During his Marine Corps career, Jason litigated at every level and forum available in the military system, from trial to appellate, administrative to collateral federal attacks. I don't know what that means, but that sounds kind of exciting. I probably want to talk about that.
Cool.
Jason earned the Special Marine Corps designation of Master of Criminal Law. Beyond only military criminal work, Jason has also practiced globally throughout Europe and the Middle East, conducting investigations and advising on frontline law of war and engagement issues in active combat. In addition to litigation, Jason has obtained a specialized Master of Law degree in the exploding world of digital evidence, electronic discovery, cybercrime, and cybersecurity litigation. Basically, he has a lot of time in his hands. The opposite of that. He is routinely sought out by military and civil litigators throughout the country to consult on matters pertaining to the digital world of litigators, as well as national security issues. He maintains an active, top secret, sensitive, compartmented information clearance and has completed his military affiliation in Marine Corps Reserves as a lieutenant colonel. Jason's practice focuses on civil, state, and federal criminal defense, military, administrative, and court-martial defense, national security and security clearance defense, as well as domestic relations and civil litigations matters. And Jason's matters have previously been covered in the Washington Post, the New York Times, and the Washington Examiner. Basically, he's just busy. So the first time
Wow.
Jason, the first time
when you read that, I feel exhausted now.
Yeah,
right?
you should be.
I feel inadequate.
My goodness.
Yeah, I was, and there was more. I did not actually say everything, but
Yeah, we don't have to keep
He's
going.
also an Olympic biathlete.
but
Right.
But I was
who builds houses for the homeless and the hungry
Exactly.
while he's running.
Exactly. I was getting a little exhausted. I was like, I don't know if I could say anymore. I was like,
Yeah.
oh my gosh. But the first time I ever heard about Jason, so I had just started on my LinkedIn presence. I had not quite retired yet. I'd started the DoD Times Redacted, and I'd started posting some newsletter articles. And all of a sudden, this guy named Jason Wareham sent me a direct message on LinkedIn, and it was very brief. And it said, "You're probably going to be needing my services soon." And I just
And he was right.
and I was just, well, who is this guy? And then I started seeing some of the work that he does. I saw him, of course, Jason, one of your more high profile cases recently was defending Captain Bradley Geary from some of the shenanigans of the United States Navy. And you have been consistently a friend and an ally to the foundation, and Jason is one of those folks who every time I call or send a message, he always gets right back to me. So from the bottom of my heart, I really truly appreciate the help.
Yeah, seriously.
Yeah,
A
seriously.
rare find for sure.
Very.
Well,
very.
we're all in the fight, right?
Yeah.
Where are the other?
One would think.
So
Yeah.
tell us a little bit about yourself, your background as a JAG, if you could describe JAG training, and then why you went into the Marine Corps, why you left the Marine Corps, and just kind of generally your impressions on JAGs versus civilian lawyers and those general topics.
Yeah. Well, the first thing I'll clarify, because there will be Marine judge advocates throughout the world who listen to this, who, if I continue to refer to myself as a JAG, they will have a slight aneurysm. And let me distinguish the differences. So in Army, Navy, Air Force, there's such things as staff corps. And in this, people who are not line officers, who have a specific staff role, and they have JAG corps in each of those militaries. In the Marine Corps, we are all Marine officers first. We're all line officers first, who happen to be judge advocates. So there's actually no such thing as a Marine JAG. There is a Marine judge advocate. And I only say that I've long ago given up giving that distinction to anyone else in my life. But I just know that there's going to be some Marine judge advocate listening to this and will not be able to hear another part of this message without their eyes kind of twitching until I clarify that. So there's that. So how did I get involved as being a Marine judge advocate? So we'll go back to undergrad 2002. And I had known for a while that I wanted to be a lawyer. And I knew for a while I'd done some mock trial stuff in high school and things like that. And I recognized that it was probably going to be trial law that I was interested in, that I wanted to be on my feet as much as possible, hooking and jabbing. And I started kind of looking at the fields available that would get me that level of trial experience right off the bat. And of course, there's state public defenders, there's state prosecutors, federal, all that. But I also was aware that there were judge advocates, right? There was the judge advocate route in the military. And that was interesting to me. My grandparents on both sides were in World War II, but I hadn't really come from a military background, didn't really have any sort of orientation to it. In fact, I've called myself the most career ignorant Marine officer of all time at every stage of my career. I just don't know what's happening and don't forecast much and just, end up paying all my way through law school. But anyways, instead of the programs that are available. So I'm looking at the field of judge advocates, and, God bless the Army and the Air Force officer recruiters, right? I fill out some form, they get a hold of me. And, both of them right off the bat, they're like, you know what, don't worry. It's not like you're really going to be in the military, right? Like more or less stating that, being like, you're just a lawyer. You'll go to some sort of fork and knife school and you'll learn to salute and shine your shoes, but that'll be it. And honestly, that was not the right tack for me. Not that I was Rambo by any means, but it didn't make sense.
Didn't it inspire you?
Yeah, it didn't make sense to me that I would be in the military. And I just, the thought was that the enemy probably doesn't distinguish that I'm just a JAG, right? And so the Marine officer, selection officer, OSO as we call them, he stopped by my house actually, and he said, look, I don't know if you can do it. I don't know if you can be a Marine, but you got to be a Marine first, and we're going to teach you all that stuff. And then if you survive, well, you can be a judge advocate. God bless. So that's what I did. That's how I became a Marine judge advocate. I went to OCS in '02, and then I actually signed for OCS 2 weeks before 9/11. So that was an interesting kind of, the world just changed and I'm going with it. And yeah, that's ultimately why I got there. And it was to have the marriage between being really in the military as well as a judge advocate.
So you like a challenge.
I do.
That's good.
Yes, I
That's-
do. And it is
good.
a common Marine Corps recruiting trait that I've since learned to say, well, we don't know if you can do it, right? And it worked on me. What can I say?
So then now you're in the Marine Corps. You
Yeah.
accepted the challenge. So
Yeah.
describe, you've gone to law school. Now describe your judge advocate training. What does that actually mean? So all of our military, non-military people can understand what that means.
Sure. So there are a few judge advocate or JAG schools in the Navy Marine Corps. Naval Justice School is located up in Newport, Rhode Island. And while you're all licensed lawyers, you all would have had to have passed the bar in order to receive the designation for judge advocate and then go to Naval Justice School. You're not qualified as a military lawyer until you complete this MOS school or Naval Justice School in the Navy. And so you go up there, and I think if I recall, it was like 8 weeks, 9 weeks, where they largely retread portions of law school having to do with evidence and other things. And honestly, I've been pretty critical about the level of education coming out of Naval Justice School. I feel like we're not doing that right, that we need to be doing a lot better job to elevate new judge advocates and establish early high standards for their work, instead of just having a couple second tour captains try to teach you evidence that your professors just taught you much better, right?
Mm-hmm.
So compared to law school, or distinguishing from law school, you do learn some law of armed conflict stuff, very light, not very helpful, frankly, when you're actually in it. And then you do learn, at least in the Navy, some, the law of the sea, a little bit of that as well. Again, not sufficiently helpful in my mind, but you get a little smattering of everything. You also learn administrative investigations and at least the regulations around investigations. There's not a lot of prac app or a practicality around, what your role would be as a judge advocate in that process, and kind of being the one that function checks investigations like you should be. But you get done, you get your certificate, and you head out to the fleet from there.
And about how long is that school?
I think it's 8 or 9 weeks. I think that's right. I'm reaching back to like 2008. So I was trying to think, maybe a little longer, maybe 2-3 months, maybe. Yeah, around there.
So over 8 to 9 weeks, you are, I guess I'll ask the question a different way. Would it be fair to say then that within the military, at least in your experience, that the body of the Uniform Code of Military Justice and all the administrative processes, which we of course focus on as a foundation with this podcast, that the school, the 8 to 9 week covers, say, 10 to 15% of that, and the remaining percentage is expected to be picked up on the job training?
Yeah, I think that's right. I mean, it's almost less than that. I don't know. I know that for me, I'd been practicing. There were some delays in getting me the right classes, class spots in getting in the Marine Corps, because the Marine Corps specifically is a little different. You do go to what's called the basic school, which is 6 months of infantry officer style training, like basic officer training in between law school and Naval Justice School. So they kind of delayed my entry because at the time we were plussing up and they didn't really have space for me. So I've been practicing about a year-ish, year and a half. And I just remember kind of reflecting on the education they were providing at NJS at the time, and it could have changed. I haven't stayed all that connected to it, but I remember seeing those around me and those coming out, and knowing, having already tried a few cases and done some good work there, that we were just not preparing people for what they were going to be facing, frankly.
And so basically theoretically, you could have a Marine Corps captain, judge advocate, newly assigned to, I would guess, an '06 level command. And that captain, that judge advocate who's advising the commander on legal whatever, administrative whatever, theoretically has less experience with the Uniform Code of Military Justice than that '06 themselves.
Yeah. That's absolutely true. Right. So my first posting was in 29 Palms in '08. And at the time, it's been restructured a little bit, especially when Congress got super mad at us for how we were handling sexual assault investigations and prosecutions. And so there was some plus up around judge advocate requirements and training. But at the time, you hit the fleet. I was in the prosecution office. There were like 3 or 4 of us. And I don't think at the time we had anyone that wasn't at the '03 level. I don't think we had a major for a long time. We had an SJA who was an '05, and she was outstanding, but she had kind of much broader duties to pay attention to around the entire base. And so our prosecution shop was 4 guys who'd been practicing, I think, the max 2-3 years at the time, and we're advising every command on the base. And I will say, at least the like 3 or 4 of us that were there together, we were all very dedicated to the craft. We were all very dedicated to kind of pressing in and learning what we didn't know and try to create a really good military justice system. And one guy specifically, he's now a military judge in Camp Pendleton, Lieutenant Colonel David Seagraves, a brilliant guy. We started together, and we really worked to have intellectual curiosity about what we didn't know. But I can tell you that that's often the rare case. Some people just hit it and they're like, well, this is what the command wants, so I'm going to do it, right? And so there's not a lot of checks on, commanders that might be going outside the line or outside the left or right lateral limits. But in our instance, we were able to pull it off. But I can see why they made reforms not long after that, because, yeah, you had a mix of people who knew very little, and the COs could easily overrule you and easily ignore you, right? Because you're essentially a second lieutenant dressed up as a captain.
That's fascinating with the parallels as you're talking, Jason. So we're very familiar with the IG, the Inspector General system, process, etc. Me, myself, as a former IG, they took me, Joe Pilot, off the street, and in 4 business days, I magically was the Inspector General for an entire installation, right?
Exactly.
And it's an important distinction to make here is that I was, I wasn't a bad American. The people who taught me IG stuff weren't bad people. There wasn't any nefarious activity, but it's just not adequate, right? You just, and it sounds like the same church, different pew here for the judge advocate or JAG Corps, depending on the service, is that it's just not good enough. And then you marry that with, you take a brand new, in your case, officer, you put him under the command, and now, just like I saw as an IG, they are susceptible to command, influence, coercion, etc. Maybe a little naivete and a little bit of you're looking to please your master, so to speak, because that master has a lot of your career in her hands. Right. And you have kind of the similar phenomenon that we see in the IG system.
Yeah, it's for sure going on, and the amount of fortitude, kind of the moral courage required of junior judge advocates who are walking into, a battalion commander or, regimental commander's office, with, sure, you learn some stuff in law school, you just memorized a bunch of stuff to pass the bar, you've been given a few weeks of training at Naval Justice, and now it's real lives, right, involved, and sometimes exceptionally serious cases, that carry with it possibilities of decades in prison, and you're having to give competent advice in that scenario and be convincing, right? And at the same time, not tell the commander what he needs to do necessarily, but at least establishing yourself as someone they should listen to. And, understandably, I don't fault them. A colonel is not that impressed with a guy who's been here, 2-3 months, right? And yet
Yeah.
I remember just going, wow, this is a pretty impossible task. And I mean, good, bad, or ugly, right? We did the job well enough that I feel like we all got our commanders to trust us in rather short order. But I mean, I've seen it go bad the other direction many, many, many times.
Yeah, sorry to derail the conversation early off here, but one of the things we hear from other former and current judge advocates is this exact dynamic of sometimes you're faced with what shouldn't be a mutually exclusive decision, but is the law, truth, justice, et cetera, and the will of the command. And that the expectation actually, and we've heard this from former JAGs and current JAGs, is that you show up and it's like, I need you to get to yes. You just tell me how to get there. And I think that's a fundamental dysfunction
Yes.
of our military justice system.
Yes.
You agree with that?
Yes, I totally do. The get to yes concept has always frustrated me. Yeah. And I could tell you, I have a theory of where get to yes has just gone, kind of so far away from where we should be, that looks at the Afghanistan Iraq wars and how we did that for, decade or more. When we started that, judge advocates had never really been pushed down to the tactical level where they were actually attaching to, the combat elements that were kicking indoors, right? And all that kind of stuff. They'd always kind of remained at a regimental level or division level where, kind of the overarching advice and stuff was going into strategy and operations. But as Afghanistan and Iraq wars became more and more complex, counterinsurgency theories became much more restrictive around rules of engagement and stuff, they recognized a need potentially for lawyers to give more direct advice. But what ended up happening as I look back is that especially new combat commanders who had just taken like a battalion and they're going forward, right? Always having a judge advocate there, even in direct tactical, like, can we shoot back as we're being shot at, right? Decision making, right? Yeah, no, this is the real thing.
Yeah.
The real thing. Yes. Yeah. And let me just tell you, the answer to can I shoot back to somebody shooting me? Always yes. Always yes. Not a hard thing.
Blanket approval.
Very easy advice. The easiest advice I've ever given is yes, for sure. So, but I mean, we saw this conditioning, or I saw this conditioning over time where commanders became so conditioned to having judge advocates, at every level and checking their command decisions every time that over a decade worth of doing that, I have the view that much of the problems we're in around leadership and how things are being handled is because commanders didn't even realize they divested their kind of moral command decision making to the lawyer. And lawyers are great at a lot of things, but we're not often great at doing what's right. We're great at doing what's legal. And let me tell you, I can make anything legal practically, right? Like, short of premeditated murder, I can give you like the left and right lateral limits of whatever you need to do and execute along a chain. But that doesn't mean that's what's good for the force. That doesn't mean that's what's good for the military member or the command, right? And so what I've observed is this, especially in the case of courts martial or administrative separations processes, especially the Captain Geary case is an excellent example where I am getting, rhetoric from the commander that I know is from the lawyer, right? And like, this is not, it's not jiving and it's dumb and it's going to walk them into a serious problem because you can't divest your decision making as a commander to a lawyer. You shouldn't do that. And lawyers should not have that role.
That's exactly the thesis and theme of our Not Me podcast,
Exactly.
where commanders said, the for whatever side of the fence you sat on during the COVAX era, you often heard from command, well, legal cleared this, and they have divested quite cowardly their command responsibility and accountability.
Yeah, and that shows exactly the other side of the coin that I was speaking to earlier, the questions I was asked, leading questions I was asking you earlier, Jason, about, so you're a brand new captain at an '06 level or '05 level command. Your knowledge of the Uniform Code of Military Justice is 8-something weeks long. And so on the one hand, how do you get the one side of the coin is how do you get this more senior person to trust you?
Yeah.
On the other hand, that more senior person is going to always use you as that Praetorian guard, that shield of, well, Jag says, the captain who just got out of the Naval Judge Advocate School, forgive me if I don't know the exact name, who just spent 8 weeks. I'm going to use this person as my shield for every decision I make because, well, Jag said. And you're just like, you're having it both ways. That doesn't make sense.
Yeah. It's so how to get them to trust you. Well, I think even as a junior lawyer, there is something to the fact that in most schools around the country, your legal training is effective. It's good in general, unless you're one of those guys that completely skated by and barely passed the bar by the skin of your teeth. You do have specialized and needed knowledge in how to evaluate a situation. And you should be confident in that accomplishment and those skills that, took you 3 years in a bar study to do. And you should communicate with your commander that, you're here ultimately to make their command tour better, to make their command tour easier, to ensure that they will be successful. And the best commanders I advised also understood and heard me when I said, there will be times where I will tell you that there's an easier way to do this, and it might not be as satisfying, right? Especially when you've got like junior Marine who is just constantly popping up on the legal report and just driving down good order and discipline. There's this feeling, especially in the Marine Corps, we've got to court-martial that guy and get him in jail, right? The whole thing. And oftentimes the easier and better thing is to just process them administratively and say, God bless, goodbye, right? So explaining to them that you're not here to like cleanse their decision making per se, but you're here to ensure good decision making is happening, and that ultimately we need to drive down your legal report and make sure that your microcosm of justice within your command is seen as fair, equitable, willing to give second chances and retrain before taking the most severe routes. And those commanders that listen to that message had a really great command tour, frankly. And a few times I had been lucky enough to, like I said, to be practicing for a year or two before I hit the fleet. And so I was able to rely on some examples of how we could be doing this better. And it resulted in my ultimate legal report being driven down. And we're not just constantly having to manage these broken toys, as I used to call them, and once they started seeing that and how much easier I could make their job, it became that trust relationship started to build,
So switching gears just a little bit. So one of the key differences that I've noticed, or at least I believe, between the military lawyer, judge advocate general versus the civilian lawyer is that the military lawyers flip back and forth between prosecution and defense. Whereas in the civilian world, you are typically either a prosecutor or a defender. Can you describe that and describe the impact that has both within the legal corps as well as the military itself? What sort of impact does that have?
Yeah. Well, so to clarify, when we say switch back and forth between prosecution and defense, it is not as depicted in the long-running TV show JAG, believe it or not. And also, we don't go and fly jets on our spare time. I was really disappointed to learn this.
Man, everything I knew.
I was like, so where's like my F-22 or whatever? Let's pull.
Oh man.
Turns out we don't do that. So in that, that show depicts for a lot of people this constant back and forth. Like one day you're a prosecutor, one day you're defense. It's not like that.
Mhm.
What it is like is you're going to do a first tour, and usually your first tour is as a prosecutor because we don't necessarily, when done right, we don't want a brand new lawyer defending an individual because there's so much more at stake there, and the standards of error are so much more lasting, right? If you're ineffective defending someone, if you're ineffective prosecuting, you lose a case, and you learn from it and you move on. It may have some second or third order effects for the command or for the victim involved, but ultimately you don't have that risk around liberty and like going to jail if you screw up.
Right.
So generally they start in legal assistance or prosecution or something like that. And I mean, one good thing I think about the judge advocate practice is oftentimes the defense and the trial counsel offices are very close to each other. And 29 Palms are in like the same building, believe it or not, separated by a door in the hallway. And what that does correctly, I think, and can be very effective depending on personalities, is it does remind you that these are colleagues, that if we're all looking at this as, when we walk into the courtroom, we're in a knife fight and we're going to go hard. But outside the courtroom, we're going to be constructive, collaborative, try to figure out the best way in most cases, except for the stuff we really need to fight about, to resolve cases and to do what's best in the long run. And those kind of juxtapositions of offices are really, really effective that way. But as the assignment generally goes, is 1 to 2 years in the prosecution office, and then you'll flip over to defense for another year or two or so, sometimes a whole second tour. In my case, I started in prosecution. Yeah, it was a year or two, and then I deployed to Afghanistan, came back, and then was the senior defense counsel for the 29 Palms base for another year or two. I extended to do that. I mean, it was really great to do it that way because, let's just say, I knew where all the bodies were buried at the prosecution office, and so we had a really effective,
Defense office.
Yeah.
Yep.
And we had a lot of fun with it, and we had a lot of collegiality between the groups. And yeah, sometimes we got into the court and we, got our proverbial knives out and we went to town, But yeah, it's a good way to get both sides. But I can tell you, after I became a defense counsel, I never wanted to go back to the other side, and I never did. I did everything I could to stay on the defense side because that's where the chessboard has to be played the best,
So with that in mind, then, so what would you say the military prioritizes? Do they prioritize prosecution or defense? Why, and what's the impact?
Prioritize is a great word. If by prioritize we mean weight the funding, give greater resources, investigation, time, attention, and training to the prosecution, yes, they prioritize the prosecution, like all the time, every day, in every way. And again, some of the fun of defense is, you're a wayward child. On the other side, you're under resourced. You are the counterinsurgency fight somewhat, and you just got to figure it out, right? You got to use your resources and connections and leverage the defense community as a whole. Like I remember reaching out to the National Association of Criminal Defense Lawyers, NACDIL, and defense shops everywhere like this. Federal public defenders, military, we're all under resourced when it comes to government funding and things. And, no one wants these terrible, horrible criminals that have yet to have any evidence presented against them to be successful. So,
I like the way you said that. So why is that? Why specifically for the military? Why, and aside from the money, the office space, all that stuff, why do we prioritize / incentivize the prosecution over the defense? And what's the impact to service members?
I think it's a very human reaction for most people. No matter what you do, especially trying to like pick a jury, for example, I come into this the most. I think it's a very natural bias for most people, to include most military officers, to say to themselves, well, if they're getting charged with something or they're accused of something, they must have done something.
Where there's smoke, there's fire.
because I myself am a good person and I have not ever experienced this. And so, being that I have never been charged with something, then the fact that they're even in this process must mean there's something wrong. And if there's something wrong, then we need to cure the evil, right? And we need to make sure that the bad person gets out or gets punished or all of those things, right? And so I don't know that it's malicious. I think it's just the good order and discipline set, tough on crime set.
Yep.
See the world in a very Pollyanna way, right? And they don't want to spend a lot of time. It's odd. I've been labeled like, well, you have a very liberal view of this, being pro like process and pro defendant and all this stuff. And I'm like, it couldn't be farther from the political spectrum in my mind. It's just what every good system needs. So I think that's the natural thing, is that we want to stop bad, right? And especially people who join the military join with the concept of an enemy, right? And it's very easy to attach the enemy to people who've been accused of stuff, right?
So what's the impact? What is the actual impact to good order, discipline, morale, command, decisions, etc.?
I think the practical impact over a set of years, if we just take a junior commander coming up the ranks and then eventually being put in the convening authority role, right, which is the role of a commander who can send someone to a court martial, right? You have to get to the convening or the convening authority level, which is usually an O5 or above level, to send somebody to court martial. I think with the conditioning around that and not spending a lot of time in commander training along the way, re-emphasizing the need to stay objective, re-emphasizing the need to follow only the evidence, right? And emphasizing the need when these, especially young commanders or young officers, are put in the role of being like a preliminary inquiry officer, right? And not having training that teaches objectivity of the evidence and confirmation bias and investigation bias and all those things that can affect us in the view of bad guy versus good guy. I think over time, it is responsible for a lot of the culture of unlawful command influence that we end up seeing.
There it is,
UCI, because it's like bad guy, bad guy, good guy, bad guy, good guy for years. And then when they get up there, they've attached the enemy concept to somebody accused like that, and they want to close with and destroy that target, right? And it ends up being putting your thumb on the scale and doing different things to kind of corrupt that process. So I think the effect is, in the long term, a situation rife for UCI.
We're talking about environmentals and whatnot. One of the things we see from the IGEO side, Jason, is that when a person raises their hand and says, I have a concern of wrongdoing, whether that be a complaint, an Article 138, something you're intimately familiar with, I'm sure, is that person...
the thing that never works? You mean Article 138, the thing that never, ever has borne out any benefit to anyone? Sorry. I might have a bias there. Sorry, go ahead.
Talking about veneers. Is that, you could be the shiniest penny, the fastest burner, the best officer enlisted member in the world, but as soon as you raise your hand and say, I have either witnessed a wrongdoing or been a victim, you suddenly become a target of the institution. And this is for what we see from the administrative side. And it will forever baffle my simple fighter pilot mind at how quickly and with such veracity that the institution turns on the person. Have you seen, maybe in recent cases, have you seen that kind of psychological phenomenon as well?
Yeah, so I've actually seen a very bifurcated and equally severe phenomena. And I don't actually have an analysis as to why one command is like this and why one command is not. But I have seen the exact thing you're talking about, where you're the best, most reliable officer in the world. You raise your hand in an EO or something like that, and all of a sudden the world turns and they're crushing the crap out of you, right? But then I've also seen almost in equal measure, right, the overreaction to an EO or something where same thing, trustworthy, completely great officer, one like E3 level will throw out, a de minimis prohibited activities, bullying accusation, which I'll just go on record. I think most of those are violative of the First Amendment, and I want more people to file on it. But they'll throw out something like that, and that person's career is crushed immediately. So it's like, and I can never guess which realm we're going to be in. But I've seen it with equal measure on both sides without any predictability. So it's severe on either side,
Yeah, that's a great point, because one of the things we hear oftentimes is we have to stop allowing these systems to be quote unquote weaponized, right? And that latter example you use is when it's being weaponized. The only way a system can be weaponized is if, in that case, and just like every other case, an unfounded allegation is substantiated, right? That's how it's weaponized. Right. If it's vetted correctly and with due process and in good faith, it cannot be by definition weaponized, but it is.
Right. And I'll say in both those cases, right, what is not present is an objective, unbiased review of the evidence on either side, right? Because in both those cases, if there was some sanity and we just take a step back and we look at it and we say, okay, we have looked at this complaint that was clearly laden with an adverse, like, I don't know, I have 100 of these, it seems, but, I take an adverse appropriate administrative action against an underperformer, and all of a sudden there's a complaint against me by them under the EO, right? I mean, those kind of things. It doesn't mean it's not true, but like, we can at least consider the intent, dive down into the evidence, and whatever the evidence shows, follow it, right? Same in the EO, like, let's protect the command, we have a star performer. Just follow the evidence, right? Just follow the evidence and see where it goes. And we're not training that well. Just this subjective, let me remove myself from the outcome or what we want to see happen here, and let's just make findings by a preponderance of the evidence, right? 51%, that's what's written in every regulation I'm aware of for the most part, and see where it goes. The other thing I will mention to kind of fix this up is it also happens that if we started to do that, we also can't be afraid of taking corrective action that is short of nuclear action. So it seems even in good investigations, right, where they follow the evidence, it's like, well, you violated the PAC order, so your 20 years are forfeit. You're done. Like, oh, you're out, right? Like, over, and I've just seen disproportionate, like crushings when we find a violation. And it seems to me like we can also reframe that and say, for the most part, with severity, variation, some things you can't rehab, but for the most part, we can rehab people, and that's okay. And it doesn't mean that your entire career is over and it's like a one and done, right? So you screwed up. Got it, right? And same with the complainant, right? So we follow the evidence. If the complaint ends up being unfounded, it doesn't mean that you made it up. It doesn't mean you're lying. It doesn't mean you're just a terrible person, should be shunned. It means that sometimes, even under a preponderance, we don't have findings sufficient to make a conclusion, right? And so if we could just shift our mind from this good and bad and evil and to follow the evidence, be proportionate in our responses and accountability, and focus on retraining as much as we can. It seems
you answered That's awesome because you answered what was going to be my
Yeah,
last question, which was what are the fixes? Number one, I think, not to put words in your mouth, but it sounds like, hey, what if we have, I don't know, something called discovery,
right,
ooh, in the administrative
right.
process. Ooh,
Whoa,
what a crazy
yeah, yeah.
concept,
Mhm.
kooky.
Well, you want me
And
on a soapbox? Let's say
Do
discovery
it.
in the administrative
Do
process.
it. Go for it,
Okay,
Jason. Jason,
so
we want to hear about discovery in the
all
administrative
right,
process.
I'm getting
Go.
out my soapbox. I'm polishing it up. So look, let me give you a great example in the Navy. This is one of my favorite examples in the world. So back in what was it, 2011? Yeah, 2010, 2011. I am no 2016. Man, it all blends together. So in 2016, I'm representing one of the 9/11 defendants down in Guantanamo, and I get a phone call, and there had just been a federal, an Eastern District of New York federal case that had come out, Bresler v. Mills, where they had reversed a board of inquiry collaterally in federal court under the Administrative Procedures Act, which I'll get to in a second. The Administrative Procedures Act is a set of laws that apply to all agencies. And believe it or not, despite the fact that there will be lawyers in the DoD and the military that tell you they're not subject to the APA, totally false. Never been found to be that way whatsoever. They just don't like the APA because the APA holds them to certain standards of due process, right? And to follow their regulations and all this kind of stuff. So, anywho, so I just learned that a case was coming back down, and specifically the case was reversed in federal court because the government regulation at the time for boards of inquiry, 1920.6 Charlie, actually said that when sent to a board of inquiry, you shall receive, and I'm gonna mess up the phrase, but essentially all evidence and discovery relevant to your board of inquiry, right? An
Mhm.
appropriate phrase, an appropriate due process. And what that meant in the Bresler case was evidence of unlawful command influence by the commandant. So Commandant Amos at the time, who I was one of the first active duty to file unlawful command influence motions against him when he did his heritage tour.
Against the commandant?
Oh yeah, again I
And
was
you were a Marine?
so yeah. Oh, don't get me
Ooh.
started on that.
ooh,
Yeah, so I was not, to my knowledge, the first counsel. A civilian counsel, Brian Buffard, longtime friend of mine, was the first counsel on the East Coast to file unlawful command influence. I was, to my knowledge, the first active duty counsel to file on the West Coast after sitting in a movie theater listening to the commandant basically tell everyone to convict more people and to kick out if ever they went to the BOI. And like, no, it was wild. It was wild. There was stuff in the brief. 90% of victims are true, right? Basically, like 90% of allegations are true in sexual assault.
Wow.
If somebody is sent to a BOI or an ADSEP, there's a reason, and the commander wants them out, and you should follow through. I mean,
Oh
like
my.
I'm like oversimplifying it, but I'm sitting here as the senior defense counsel, again a captain, listening to the 4-star basically taint my jury pool and give jury instructions and commands to convict, and I was just like
Oh my
losing
God.
my mind. I can't believe this was happening. And mind you, this is what really did make my career. It just popped off a whole career of UCI fun and excitement from that point forward. But in that same case that I filed the first UCI motion on, I always say to my knowledge because nobody's contradicted me, but just so happens that we moved for discovery. The court ordered production of the video recordings that I had saw 3 combat camera people set up recording. And wouldn't you know, those videos just disappeared.
Shocking.
Yeah, shocking.
mm,
Here's my
Shocked
shock.
face.
kooky.
Right,
Shocked face.
exactly. And I was just like, I could not believe like what I was dealing with here at the highest level. So, anyways,
Guantanamo.
I'm repping a guy at 9/11, and I get this call that the Brother B. Mills case is coming back, and it was on a discovery issue. And believe it or not, they're like, look, we really need somebody senior to handle this case, especially somebody who's dealt with the UCI stuff around that particular commandant staff group. And I said, okay, sure. So they detailed me to the rehearing, the Brusler case. And it is of interest to most people because Major Bresler happened to be a reservist, a reserve Marine, who was a full-time New York firefighter. So at the same time I'm representing a 9/11 defendant, I'm representing a New York firefighter, which I found wild and interesting. But the import of that around the discovery is the Navy's response was not, oh, we need to make sure that discovery is fulsome under the law and under the regulations because, the federal court said so.
Mm-hmm.
Instead, they're like, well, if the federal court's going to make us follow our own regulation, guess what we're going to do? We're just going to change the regulation. And so 1920.d comes out and basically says you only get discovery of what the convening authority thinks you should get discovery of about the instant, like minute charge that they put in front of the BOI. So anything else affecting your due process, anything else affecting the ability to like collaterally impeach the facts or witnesses. Oh no, you can't get that. You can't get that at all. And so I have yet to have it squarely in my sights in a case to have that entire reg flipped for just violating foundational what process is due requirements. But like I am waiting for that perfect case so that I can just smoke this. But this is the mentality. This is the sickness in my mind, and why I was fully supportive of the recent administration's just like sweeping dismissal of most of the judge advocate generals, because a system that says to itself, instead of ensuring our process is fulsome and fair, we're just going to manipulate the process and change it.
We're just going to change it, right? Yeah.
Yeah, we're just going to change it so it's more of a rubber stamp. I mean, I don't know how people who wrote that regulation can look at themselves in the mirror, right? Lawyers who think that way, despicable to me. And so this is my soapbox on discovery in the administrative process.
And for those of you who, most listeners probably know what we mean when we say discovery, but in case you don't, discovery means non-legally, Jason, of course, but discovery means you have both the defense side and the prosecution side have access to the evidence, whatever the evidence is,
all
of it, and you also have a reasonable amount of time to actually review the evidence. So the defense does not get the evidence 3 hours before or during the trial,
right?
While the prosecution's had it for months. Not that I've seen that.
Looking at you, family advocacy.
Oh no, you gotta get me on the FAT program now. Like
if you're fat, I'm looking at you through the podcast.
Or even one of the Article 32 hearings I sat in recently. I think I asked you about this, Jason. I was like, I think I sent a text message to Jason like, hey, I'm in this Article 32 hearing for this guy, and the prosecution is giving the convening person, whatever the name is, more evidence during the articles. I'm like, is that I don't understand that.
Well, you should understand that. It doesn't make sense. It's not cool. But yeah, I mean, I have a whole other soapbox for fat. We don't. I think we should.
I think everyone probably.
Yeah.
So one of my last questions, or my last question actually, because I know we're getting pretty close on time, is I wanted to ask the risk question, but I think we've kind of covered that. But if you want to cover that as well in this question, I'm going to ask you. But big question for all of our listeners: if they are in a situation where they need to go talk to their local defense counsel, what should they know and how should they prep themselves before they go talk to the defense counsel? So to make the defense counsel's job easier to represent them, given the defense counsel is under-resourced, overworked, has one computer per office, 17 cases, prosecution has one case, so on and so forth. So how can that person prep themselves to make the defense counsel's job easier to help them?
Sure. So probably the first thing I would say is there are certainly some exceptional active duty defense counsel. There are certainly some just stellar lawyers in that realm. I can tell you though, looking back, if ever I were really in trouble as like a junior Marine or junior officer, I would probably first consult with one of the civilian military practitioners. Most of them do free consults. I do free consults for military vet, right? And I would at least get their perspective first, because the fact is even the stellar judge advocates assigned to the defense role They're usually maxed out 4 or 5 years of experience. Most civilian military practitioners, we're looking at 15 plus, and so just a consult around, what's happening, what's going on in their perspective. And, I'm not going to go through a list of who the great ones are or who the bad ones are, but there are some good and bad ones. Look at the websites and get, make sure they've been doing it for a while. But what that gives you is kind of a really good outside perspective of everything that's going on around this issue. And sometimes I do this in the consult. I say, look, on this level with this evidence and in this command specifically, I know there are some really good defense counsels and I know that they can handle this. If you need me to tag in at some point, great, tag me in. But for the lesser offenses, I usually just kind of give them an outline of what they should be thinking or looking at. And then some of them end up wanting to hire me, and it's fine. But sometimes I send them back into their defense shops. And then as you go into the defense shops, keep in mind that, at least especially in the Marine Corps, customs and courtesies, if you're enlisted to officer, are one thing. But in a lawyer role, they are ethically required to listen to you and to answer your questions, and you're meeting them not in a subordinate superior role. And so, be respectful, but do not allow a defense counsel, because he's an officer, to kind of intimidate you or otherwise, just tell you this is how it's going to be. But say, hey, sir, or ma'am, I've got some really real questions here I'd like to know. And in that, ask them how many cases they've tried, what kind of cases they've tried. Have they ever dealt with this particular command or commander before? What they think is your largest danger points, what they think they foresee the process being here, what they think the probable outcome is, right? Both in the best case and then the worst case. And in any defense counsel of their worth will be able to answer almost all of that after getting kind of a nice 10-20 minute description of what's going on. And if they can't, then they're not the right one. And the thing to keep in mind is that you are allowed to talk to a different defense counsel. You're allowed to get a different lawyer. You're allowed to request what's called individual military counsel, IMC, which is a detailed lawyer from outside the command or from somewhere else who's more experienced. And so this is not, I think a lot of enlisted especially just are like, well, this is the lawyer I got and that's my option and he's a captain, so I have to listen to him. And that's not the relationship here, right? The relationship is you're the client, I'm the attorney. I have ethical duties to ensure that you're communicated with, that you understand, and give you a fulsome and complete evaluation of your case. Recommendations, Did they answer the question? I think so.
Yeah, no,
Yeah,
absolutely. I would have never taken on that tack that you just now took. That is, and you're absolutely right though, because if you're going to go see a defense counsel, you're already scared, you're already paranoid, you're already everything. Your whole life is on the line essentially.
Right.
And so you're almost like a lamb to slaughter, and especially if you're a junior person, you're going in there and you're talking to an officer.
Right.
And you just think, okay, I'll just take whatever they give me. But no, in actuality, you have real rights and you can demand those questions regardless of the rank.
And to the judge advocates listening, right? Be better. Listen to your enlisted clients. Don't just assume. The number one thing I've seen from junior defense counsel is an enlisted person comes in and they start giving a fact pattern and they just pigeonhole them into a fact pattern that they see more regularly and all this kind of stuff. And they're not asking searching questions. They're not asking, open-ended questions. They're just like, oh, this is fact pattern alpha on this kind of thing. And this is what's going to happen, and you need to get over yourselves. And I had to tell myself this, I'm preaching to the choir, you need to get over yourselves, realize that every case is different down to the minutia, that the devil is in the details, and that is your client or prospective client. That is not a private or a lance corporal or whatever. And you owe them the duty and responsibility to meet them at their level, to make them feel at ease, and to help them walk away feeling that they've got somebody in their corner. And if you're not doing that, you're not being effective, because there's no trust And often the key facts that I receive that allow me to win something come only after my clients really trust me and they're willing to open up about things, right? Or even if I don't have a defense on the facts, but as they start to open up and trust me, then now I have mitigation evidence. I have extenuation evidence. I understand where Corporal Schmuckatelli came from and their background and why we ended up here, right? Because for most part, people who join the military are doing so because of a sense of service and a sense of like good intention. And they are not your run of the mill, like gangbangers since they were 8 or whatever. And so the fact that we're now charged with a serious crime or accusations, or anything going to court martial, it's usually an act that is completely outside of their standard character. And you need to understand that, right? And if you're not taking the time to understand that, you're not doing your job.
And perfect segue, because one of the 2 fixes you had suggested prior to our discussion, Jason, aside from discovery, was proportionality. And I'd like to kind of cap it off the show here by saying, look, and it will also continue to befuddle me that we take the honorably serving 1% of this country, the very few who raise their hand and are willing to sacrifice so much to include their lives for the service. Right. And we continue to invent ways to just
crush them.
It just crush them.
It's crazy.
And it should be the exact opposite. Yeah. They should be given at least as many rights as an American citizen, A, an aside, but B, they should be given grace. Right. Like, look, you are serving, you should be given, if not the benefit of the doubt, at least grace when you're found to be culpable of something. And we do the exact opposite. And the UCMJ is designed really for that purpose. So not to put words in your mouth, but the proposal for the entire system, the military leadership and our nation's leadership is to go in with that mindset, is that we've in a day and age where finding a number of qualified candidates, even at the beginning, is difficult and becoming more difficult. And then finding people who want to serve is more difficult. We're not enticing them by making more ways to ruin them over and out.
Yeah. I mean, so look, I've said it on like Sean Ryan's show and other things related to Captain Geary's case, but truth, transparency, proportional accountability, it's a national security issue. It is a national security issue because if we are not doing this, A, we are losing our human capital we already have. B, we are broadcasting to the United States of America and its people that they cannot trust their sons and daughters to this system. They cannot trust them joining the military. There is too much risk, right, in doing so, inherent in the problem. And so this is not something that's just a nice to have. It's a requirement. It is an absolute requirement, or we're going to continue to have the recruiting issues that we're having. We're going to continue to hemorrhage people who are of our highest quality and effectiveness,
Yes.
And it all comes down to trust, right? Mm-hmm. Can we trust that we're going to be treated fairly? Can we trust as officers that if there is an error, we can be rehabilitated? Can we trust that I'm going to be able to defend myself from an accusation if it pops up with all of the evidence that I need? Can I trust that even if I did something wrong, that somebody is going to come alongside of me and exercise leadership still in that moment and say, here's your proportionate accountability and your map to coming back from this, right? On enlisted and officer side. Mm-hmm. And without that, we're going to fail, right? We're going to fail. And it's going to break at some point.
Yep, absolutely. Well, Jason, we really appreciate you taking the time to come on our show.
Great show. Thank you.
All the way from the West Coast, enjoying where are you? San Diego?
San Diego. Yeah.
San Diego. Yeah. San Diego sunshine. So thank you again for coming on the show. Thank you for everything that you're doing to increase the possibility for justice within our military, outside the military. And we will chat soon.
All right. Thanks so much, guys. Appreciate it.
All right.
Thanks, Jason.
Bye. Well, that's it for this week's topic. We really appreciate you tuning in. Don't forget to hit that subscribe button if you haven't already, and check out our foundation website at walkthetalkfoundation.org.
And feel free to reach out and give us feedback. You can get a hold of us via Facebook, X, Instagram, LinkedIn, and our foundation's website. Details in the description section. Thanks for tuning in and see you next episode.